Okay, I'm here at the Ventura County website, and I got a response answer from Commissioner Snyder upon my request that she recuse herself. And, yeah, it's not going to happen. She's not going to recuse herself. She feels, I mean, at least she responded. I'm going to give her credit there, right? And definitely responded with her reasons why she feels that she shouldn't have to recuse herself or that she's not disqualified. And pretty much it boils down to, even if she made incorrect decisions regarding my case, and even if, you know, she did rule 99.99% time on behalf of the defendant, that doesn't, it's not a legal reason for her to recuse herself. So, okay. And one part I'm reading here, because I already printed it out, obviously, is that she states that, you know, there are 3 defendants, which I've been stating all along. There are 3 defendants, and that I should be allowed to collect from defendant number 2 and number 3, which is Remy Hutchins, the grandson, and Kathleen Curtis, the ex-tenant. And I even put in a court order and answer requesting to be able to collect from them, since the commissioner refused to end that contract with defendant number 1. And she's saying that, you know, I should have be going after defendants number 2 and number 3, therefore she's not blocking my ability to collect the judgment. And that, you know, apparently she gave me permission to go after 2 and 3, but, you know, the courthouse, the clerks at the courthouse, said no, I could only go after Linda Crosnoe, defendant number 1. So clearly there's some miscommunication happening there, right? So I've got 10 days to respond to this. I'm done, like I said, in 2024. My resolution is I'm not going to chase the money anymore. I'm just going to let that writ of execution get used as much as possible before it expires in March. And after that, yeah, I don't care about the money anymore. I just definitely still want to have a restraining order against my neighbor. So hopefully that'll go through. But, yeah. I'm tired of trying to chase the money that was awarded to me by 3 other judges. It's that's great. It's not even $2,000, okay? We're talking, you know, that's a lot of work to try and get $2,000. I can't believe I've invested 6 years in trying to collect the money. And, yeah. It's only money. It ain't worth this much effort, especially for this little amount of money. Okay, I'm off work, and I decided to go ahead and give another look at this order striking down my request to have the judge recuse herself willingly. And I see where I made my mistake. I do. I should have never have even entered that contract. Right here, June 3rd, 2019. When she first met us, and the purpose of this examination is for the judgment creditor, in this case plaintiff, to identify the property that a defendant has or may have in the future that can be used to satisfy a judgment. Both defendants were sworn and examined. I denied the plaintiff's request to view the driver's licenses for lack of relevance, such information needed for repayment to the judgment, overriding privacy concerns. Now, in any business, mine at least, if someone gives me a check, I need to see their driver's license so that if the check bounces, I can chase them down, right? Right. When you open up a checking account, you have to show your driver's license. And basically any business, yeah, if you're taking a check, you're required to show your driver's license. It was at that point in time when the judge denied me the right to see the driver's license. I should have said, well, then I'm not going to do the contract. But, I didn't think, because I've never signed a contract with defendants before. I didn't know how it worked. And also, the fact that the contract was not honored. It clearly stated at the top, if there was even one missing payment, I could end that settlement agreement. And so here I am 6 years later, now trying to get the judge to recuse herself because she denied me the right to see the driver's license. And then after that, she denied me the right to, end that settlement agreement. She says here that she denies that she has blocked plaintiff's efforts to collect my judgment. On 2/3/19, I conducted this and that, and then on June 5th, I denied plaintiff's request to end settlement agreement because defendant Crosnoe had established a history of making payments. Yeah, she established a history of making payments late. Not on time, and destroying my property every time she would make a payment, a $50 payment. She'd go break something or steal something. But, okay, that's irrelevant, right? And, it definitely says that, as stated, I ordered the defendant to become current within 5 days of the June 5th hearing. And she did. And if everybody recalls, I said, no, I do not accept that. I want to end the settlement agreement. And she points it out that I argued the point, and she said, sorry, thank you, leave. Yeah. I do have all the audio, fortunately, but it is not worth it to me to put in this writ of mandate. At the end it says I have 10 days to respond, or I have my lawyer do it, whatever. And of course that costs me money, right? I'm at this point going to be spending more money than what the actual judgment was. So I'm done chasing the money. And even if I put in this writ of mandate showing that I definitely still need to have her remove herself from this case, odds are it won't happen. And I spent the money for nothing. And in 10 years I can just renew the judgment. But even though she won't remove herself from the case, there is no law that says I have to go back into that courtroom. Because if I'm not chasing the money, I don't need to go in the courtroom. Right. I mean, she can't be the judge there for 20 years, can she? I don't know. It's not, clearly the commissioner has chosen not to recuse herself, despite my asking her to do so. And she feels that she is not prejudiced in this matter, and she has not blocked my ability to collect the money. And, the fact that I granted on September 11th plaintiff's request to obtain a writ of execution against co-defendants Hutchins and Curtis reflects that I have not blocked plaintiff's efforts to collect her judgment. She hasn't blocked my effort to collect the judgment from defendants number 2 and 3. But she definitely has blocked my ability to collect it from defendant number 1. 2 and 3 exist because of defendant number 1. And, okay. Like I said, I have never worked so hard for less than $2,000 in my life. That's all I'm trying to get here. Not even $2,000. 6 years. And I've spent probably like $1,500 trying to get $2,000. Yeah, they say you're supposed to spend money to get money, but I don't think it applies to this. Yeah. No. I should just be able to get this money, and had the defendant just willfully paid off that debt, I wouldn't be here. Had I not signed that contract, I would not be here. do yourself a favor. If you're given the opportunity to sign a contract with the defendant, do not do it. It will not work out in your favor. Odds are good. It will not work out in your favor. And if the judge doesn't let you see the driver's license of the defendant, that's your sign. You definitely don't want to sign a contract. Oh, and this, yeah. As an additional matter, plaintiff overstated the amount of the outstanding judgment which he obtained the unauthorized writ of execution against Ms. Crosnoe. It was authorized, obviously. It's filed in the clerk's office. And it's not overstated the amount. I have canceled checks for every amount that the Ventura County Superior Court took and cashed. I'm only claiming the money that they took. They cashed. Yeah, it's called cost after judgment. So I'm thinking maybe she feels I overstated the amount because that's what the defendant feels. But, yeah, because the defendant gets everything for free. All her costs are waived. Not one penny of my cost has been waived, except for the defending, the thing I've got going right now where I'm trying to get a restraining order against her. That cost was waived. So, but two separate cases, clearly. Yeah. I regret even contemplating signing a contract with the defendant. But you know, live and learn. I'm never going to see the money. Okay, today's date is January 25th, and the official, I am not going to recuse myself, came in the mail today. Yep. So, of course, I decided I needed to write a response. And basically, I'm just pointing out that, in response, that the driver's license is relevant in any business transaction that accepts a check in the event the check should bounce. And plaintiff did not overstate the amount owed by defendants. It's called cost after judgment. The filing fees have been required by the Ventura County Superior Court and the sheriff that the plaintiff is legally allowed to add to the memo of that cost. If anything, plaintiff understated the amount owed. Plaintiff did not charge for the reams of paper, the inkjet printer, the ink, the envelopes, the postage, the required overnight mailings, all totaling over $700. As the plaintiff, I shouldn't require your permission to collect the judgment awarded to me due to the actions of the defendants against me, actions of intentional destruction of my property, and false accusations of elder abuse. At the claim of exemption hearing, you did not even require the defendant to show proof of finances, nor did you question how she was giving that defendant, number 2, Remy Hutchins, $1,400 a month, when she claims she does not know where he is. It is clear you're not looking out for my best interests, nor do you feel I have a right to question your decisions, opinions, beliefs without it being considered a disruption in your courtroom. I currently have a restraining order against Ms. Crosnoe due to her continued destruction of my property and harassment of me. Now, you know, that'll probably just, if it even gets read, I'll be surprised because, you know, I did have to mail a copy to Commissioner Julia Snyder at the Simi Valley Courthouse, and then file it with the clerk's office and a copy to the neighbor, defendants 1, 2, and 3. So, yeah, I'm done of having to keep mailing shit to people. And as well as just having to keep printing out stuff and keep spending money. I'm not going to get the money. But my lawyer, today, we spoke, and he's come up with this possible solution. And I think I'm going to let him do it because it would put an end to, I guess, me trying to collect the money. He wants to, basically, he's going to send her a letter outlining what she owes to be current because she hasn't made a payment since January last year. And at $50 a month, that brings it to $550, right? Actually, for February, it brings it up to $600. But okay, anyway. And then she would have to continue making payments to his office. All to him. Just mail it to him. He will mail it to me. And then he will keep tabs of any time a payment is late. Anytime she does any further destruction on my property. Basically, this way I don't have to communicate with her. I don't have to keep tabs. He'll do it. And then when that thing is paid off, then yeah, we'll put in the satisfaction of judgment and remove the lien off the property at the Ventura County Recorder. So I think that's a good idea. So he is going to send her the notice that he will act as the agent. And that way the payment still gets made. And I don't have to keep issuing a writ of execution because I told him I don't want to do it anymore. I don't want to keep spending money to get money. And clearly, if she doesn't make that payment, he'll be aware of it right off the bat. And the judge will, at least maybe listen to him, because I don't need to be talking to the judge anymore. The judge thinks I'm overcharging her by claiming those court fees. They're legal for me to claim those court fees. I have to write a check to the Ventura County Superior Courthouse. I'm allowed to legally claim any filing fee I have to pay, any sheriff fee I have to pay. It's called cost after judgment. And so maybe this will cut my cost after judgment. I just know I'm tired of chasing the money. And my lawyer is perfectly capable of acting as the receiving agent of those payments and keep tabs of whether or not they're made or not made. And that way she, like I said, has to keep sending it to his office. Could work. Maybe. I don't know. But in the meantime, yeah, I had to mail this, so I don't know what the judge is going to think when she sees this, but it doesn't really matter, I guess, because she won't recuse herself. And I don't want to ever have to go in that courtroom again. So, and since she won't recuse herself, the next time for me to file or renew that judgment is in 3 more years. And by then, she's probably going to be in a different courtroom. Who knows? Hopefully. Okay, so yeah, it has been over 6 years. I'm done. I am tired of having to deal with this court case due to my neighbor. And I'm going to let my lawyer help me. And, well, the Commissioner, Julia Snyder, she definitely refuses to recuse. So I got to let my lawyer help me out on this. Because, like I said, after 6 years, it just isn't worth all this for money. Seriously, I've never worked for money so hard in my life. And I don't want to do it anymore. I don't. So, yeah. I'm handing the reins over to my lawyer.